All right. Hi, guys. Hi, guys. We're back. Tiffany, hi.
Hey.
Are you
It's one of those
tired?
days today. Yes. It's one
Yeah.
of those mornings, one of those days, it's just one of those days. I feel like Monica. It's just one of them days.
All right. Don't take it personal, guys. Don't take it personal.
Yeah.
It's yeah. You know, guys, we love you. We love you. We love you. We love educating, but sometimes it can be a little exhausting behind the scenes, you know. So we want to continue our conversation with that branch that we had trouble talking about last week.
The judicial branch.
Yes, the branch where the laws and the judges are, that one.
Mm-hmm.
And I started messing it up, so I don't want to even say the word now and start laughing. So that branch. So this week we thought it was important to really discuss significant cases that have changed our life, but in the sense that in addition to you knowing what those cases are, knowing how they are making decisions even today based on those cases, because you never know when you'll have a case before the judges. Anyway, so how do cases get to the top court? We talked about the levels of court last week, the lower court, the middle court, every state having a Supreme Court. And then we know that the federal government also has a Supreme Court, which was actually in the news, been in the news in the last year.
Yeah.
Controversy because Ruth Bader Ginsburg died, and usually there's 9 judges on the court. And so now the current president wanted to select a new judge. And we talked about that last week. You know, you can go watch that, about the difference between select and elect. Now, all Supreme Court judges are selected by the president, and then they go through the process of confirmation. So just recently, now what's important to know about this, why this judge selection was so controversial, was because when Barack Obama was leaving office in his last year, he wanted to pick a judge. And they were like, no, you can't, because you're on your way out. And if you're selecting the judge, people got to agree with that. So he didn't fight for it. He didn't get it. But now our current president, within 2 months of leaving office, picked a judge. That's a big deal, right? What do you think?
I think it's a big deal, but we spoke about that before, and I feel like when you're in power, you change the rules and make the rules. And I mean, I always say I play games with the 8-year-old, and sometimes we make up new rules. And if he won and he's the decider, he gets to make up new rules, and that's pretty much what they did. They played the game the way they wanted to. So that's the way I feel about it. I'm not happy about it, but I mean, hey, when you're in power.
When you're in power, but I was pissed in the sense of, if you have, it seems like the Democratic Party doesn't fight the same way the Republican Party fights. And so
they don't have balls, like they don't have the audacity.
And that just pisses me off, because I'm like, well, if he had the power to do it, and he literally had like a year left in his presidency, he should have did it. Because when this guy had 2 months left, he did it. So
well, he did do it, and the problem is, based on what Mitch McConnell was saying, was that Merrick Garland was never going to get the votes that he needed to get confirmed. So why go through with a hearing?
Well, I still would have dragged it out, because I'm a petty Betty like that. I would have just dragged it out.
You never know who was going to vote for or against it. So
right. And this current president has been known as packing other. Now, guys, remember, it's not just the Supreme Court that the president has power over. So he picked lower court judges also. So he was able to pack a lot of people in the courts. Why is that important? Because now there's a lot of cases going on in the courts about his right to the election. So if he wants to steal an election, he has a lot of judges that could potentially uphold his case. So anyway, so that's what we wanted to talk about today. So how does a case get finally to that last level of Supreme Court? So it's a long process, but just to be very brief with it, I'm gonna look just briefly at my note. I had a note on it. So basically, when you exhaust your levels at the lower levels, you keep exhausting, you keep losing, then you file what's called a writ to go to the Supreme Court. Then there's a guy, I'm just going to say a guy, it could be a girl, it could be a person. It's called the Solicitor General. They decide which cases, because really the Supreme Court, that's why I said we don't have a true democracy, because the Supreme Court only hears like 80 cases a year. Out of the thousands that they get, they pick out of these, they pick the most controversial cases, the ones that are going to make the biggest changes, right? So this person, the Solicitor General, decides, okay, these 100 cases I want to put before the judges. Then those judges, they have a meeting. Do y'all want to listen to this case? Y'all want to hear this case? They vote. So they vote to say, okay, I think we should hear this. I think we should rule on this case right here. So then that's how your case ultimately gets to the Supreme Court. That's a very long, drawn out process. Yeah. Now, what I found interesting, Tiff, was that even if you're not the one suing in the Supreme Court, you can influence the Supreme Court. Did you know that?
No. Well, you mean like other parties of the Supreme Court? Yes, but if you're talking about like having right to certain, I guess, aspects of the case, I didn't know that. Right.
No, you have not rights, but what they call, you can, okay, so the two parties are suing and they're both going to the Supreme Court case. But you as a third party have an interest in the case. You could write a brief.
Okay.
And it could be considered for what you're like, let's say smoking, let's say the abortion cases that are probably going to start coming up now. As women's rights groups, a women's rights group can file an amicus brief, a friend of the court brief. They can say, we have an interest in this case. We want you to rule on this side or that side. So it becomes like, or cigarette, you know, those political action groups, even like all of the civil rights groups right now, Black Lives Matter and stuff, when those cases come before the judge, you can actually get a lawyer and have them file a brief to say, hey, Supreme Court, I think you should rule in our favor. I think you should rule this way or that way. And they will read them.
Wow.
And I thought that was very interesting. So you shouldn't really be detached from the new cases that are coming out, because you can influence, especially now that we're looking at things like qualified immunity, police brutality, chokeholds. We're looking at all these things. I think that it would be important to know what cases they decide to take. And if you have an interest in them, to say, hey, I have an interest in them.
Yeah.
So what I wanted to do, let's talk about some old cases. Before we talk about the current ones, I think we should talk maybe just briefly about some of the old cases that have really changed America. So like we wanted to go in order amendments. So the First Amendment, which we all know, is speech, freedom of speech, freedom of press, freedom to protest. So there's some cases in there like about flag burning, because remember at one time flag burning was illegal.
Yeah.
Now you can do it. So now you can burn your flags. One case I thought was interesting from 1965, which is the Tinker case. Kids wore armbands to school to protest the Vietnam War. And they got suspended. So now teachers want to wear Black Lives Matter's mask. And there was a current case where a teacher wanted to wear a Black Lives Matter mask, and they were talking about should she be fired. And I was like, well, Tinker, according to the Tinker case, school, you don't lose your freedom of speech when you go in the school system.
Right. Well, you don't, I don't know, how did they rule? Because you don't lose your freedom of speech, but certain things cannot be worn. And it depends on how, if it's a political or if it's a, considered, like you can't wear something that has curses all over it, or you can't wear something. So there's a limit to the freedom of speech whenever you enter to a public domain.
There is a limit to freedom of speech. There was another case that mentions that is the Abrams case. He had anti-war paraphernalia, and it was like speaking angrily against the government. This was like in 1919. And he said, I have a First Amendment right to speak against the government, but they were like, not if it causes drop problems. So yes, your speech is limited.
Like you can't yell fire on an airplane. That's something that you're not supposed to do. You can yell fire if you're in your home or if you're on the, like, I don't know, on the street, but in an airplane, for some reason, you can't do that. So your freedom of speech and your freedom to, you know, certain freedoms are limited based on certain restrictions within
Yeah.
The
So
government.
that is what the Abrams case of 1919 said. You can't just say freedom of speech, but a Black Lives Matter or MAGA. I know I saw people wearing MAGA masks and hats and stuff, and they were not allowed in certain stores. Now, one side would say I have freedom of speech. The other side would say that's a disruptive thing because people are going to get angry with you. Yeah. Those two phrases, Black Lives Matter and MAGA, are kind of they incite riot. They incite people to get angry. So
what people believe the significance.
Yeah, they believe it. It has a perception of being like for violence or something. It has Black Lives Matter has been portrayed as being racist, Antifa, they've been labeled. So we will see those cases come up. We will see those cases. I'm looking at my time because I want to make sure we have a time. But so that's First Amendment. Second Amendment, I know you had one under Second Amendment.
Yeah, actually, it is interesting. Well, one, I want to point out that in order to be a Supreme Court justice, you do not have to you are not required to previously have been a lawyer or to have previously been a judge, which I found very interesting. No, you
don't need a law degree?
Kim Kardashian can become justice of the United States, a Supreme Court justice.
But to be president either, you don't need much to be president either. Because Kanye was on the ballot.
Yeah, I found that really, really interesting that you don't need that. You actually just have to be a student of law and practice under a lawyer. And the last Supreme Court justice that wasn't, he actually, it was in 1941, I forgot the person's name, but he actually did not have a high school diploma and he studied under a lawyer and passed the bar.
So he was an apprentice, because she's an apprentice.
Yeah. Yep, that's basically what it was.
That's scary. That's scary because
to actually govern. Yeah,
that's very scary because the laws there are final. How about that?
Yeah.
How about that?
Just keep that in mind that you don't have to. You do have to have knowledge of the law and the background, but you don't have to have previously served as an attorney or a judge.
Wow.
But that being said, so since 1939, it hasn't been many significant cases that's come before the Supreme Court for the Second Amendment. And in 2003, I think it was 2003, there was a case called Heller where they were trying to determine what the right to keep and bear arms meant.
Yes.
So the right to the Second Amendment it indicates a well-regulated militia. So they were trying to determine if the law that was put in place, I think it was in Washington, D.C., that you had to have your guns, that there was a ban on handguns, I think, and you had to have your guns unloaded and locked when they weren't being used. And they said that was infringing on their rights to their right to bear arms. And that the Supreme Court actually upheld Heller. So when you have a weapon, you can keep it in your home loaded. You don't have to have, and I think that was in Washington, D.C. So you don't have to have these regulations, even though when you look at the Second Amendment, it says a well-regulated militia. So that means that militia. That means that when you it's regulated in some form or fashion. So the government should have some type of regulation over how and when and where, what you can do with your weapons. Not that you can't have them, but there should be certain standards around having those because of the regulated part.
Which is why, while you were talking, I was thinking about all the current Second Amendment people saying, I'm not going to vote for Biden because he's going to take away our guns. I'm not going to vote for you because of whatever. The Second Amendment people tend to be more Republican because Republicans tend to uphold the Second Amendment. That was mainly what this current president would always talk about. He's going to take away your guns. He's going to take away your guns. But they really don't understand the Second Amendment because, like you said, regulated. And then that regulation goes to things like what type of gun?
Yeah.
Should you be able to have a semi-automatic in your house? Should you just be able to have a simple handgun to protect yourself? So when they say regulated, they not only mean other deals about your age, like what age should you be able to get a gun? People in the other, Second Amendment states, Midwest and stuff, use hunting rifles and all that kind of stuff. And so kids tend to be able to learn how to shoot I'm in Brooklyn. Ain't nobody gonna be telling a 12-year-old saying I'm a hunter and I want a gun, you know? So that's part of the regulation. But I think it's interesting that they always, you know, people that for the Second Amendment that won't vote Democratic will, for the Democratic president candidate, will say, oh, I'm upholding my Second Amendment. But the Second Amendment has limits, just like the First Amendment. All of these things
Everything
have limits.
Yeah.
Right. You can't have an arsenal. Like, we should just let you have a little army in your house. I mean, how much are you protecting yourself?
Some people do. I said some people do. But
yeah, they actually right now they have a shortage of bullets. Right now they have a shortage of bullets. I know Walmart was saying we're not even selling guns anymore right now because it's such a tense time in the climate. When the presidential election happened, in addition to boarding up your stores, we need to stop selling. I remember when I went into Florida years ago, maybe like in 2000, I don't remember what. We went in Walmart and the guns was just right there. And I'm like, really? Because I'm a city girl through and through. I was like, really? Just guns just like right there for sale? And I mean, I don't know if it's still like that. Is it still like that?
Yeah, pretty much. Not right now, but yeah. I mean, you can go in gun, you can go in rifle stores, you can go in certain hunting stores and still access.
Well, I get the rifle store, but Walmart?
Yeah, I mean, they actually, I haven't been in that section in a while, but they yeah, you can. And not right now, because like I said, I think they stopped the sale and the display of them. So I would have to check that.
Wow.
Next time I go to Walmart, I'll let you know.
That's wild. I mean, I know when we go to Dutch country, I think they do have areas in the back where they have weapons and all that stuff, but you just wouldn't see that in the city. You just wouldn't.
Yeah.
People be like robbing the store. All right, so you ready to move, or you wanted to say more?
Well, yeah. We can move on to the next amendment and go. Yeah.
Okay, so I thought,
like I said, guys, this is one of those days. Okay.
I get it. No, I get it. We we have our days. Fourth Amendment is search and seizure, and I think that one, to me, when I was reading some of the cases, I thought that one was very relevant to today and the issues that we are having with police and police overstepping their bounds. So that's like the Breonna Taylor's case was no knock warrant, right? So that's sort of like searching your house when you're sleeping. There was a very interesting case in there about it was in 2006 where two people married, living in the same house, and I guess they got into some sort of a dispute. It's, I think, Georgia v. Randolph. They got involved in some dispute, and she called, let's say the woman called the police, and the police came, and she gave them permission. I'm just saying she, I don't know which one, gave permission for the police to come in, but he didn't. And so the police were able to come in. So that raised the question, if you both live in the same house, and I say the police can come in and search, and they found something, I think they probably found drugs or something. So now, is that a legal search? Because I'm an owner just like you are. So I tell you, you can't come in, and he says, oh, you could come in. I'm like, no, you can't. And then you find something and it incriminates me. Wow. That's not, so that case was ruled that's not a legal search.
Yeah, because it was his, if it's going to be against him, the person, then he did not give the specific permission for the search.
Because you have to give permission without a warrant.
Yeah.
I called you, so you don't have a warrant. You can, that also leaves the question of, which is not on any of the cases that I saw so far, but there's a lot of recent issues of ISIS walking up to people and asking them for their papers. Are you documented as being here? Searching your car. If you get pulled over driving, if you get pulled over, how much of a search do they have? So, you know, that case, Randall, I thought was very interesting. There was a case back in, I don't remember the years, MAP, it's called MAP. I think it's MAP v. Ohio. The guy was walking funny and strange. He was Caucasian, walking strange or whatever. And the cop thought it was suspicious behavior, so he stopped him. they ruled that it was okay because he was suspiciously walking. But in one of the dissenting opinions, a dissenting opinion, guys, is when the Supreme Courts write their decision, they don't always agree. So when one side doesn't agree, they kind of say, well, I disagree because this and that. And so they write an opinion. In his opinion, he's like, what is suspicious behavior and how far does that go? So let's say I'm angry. Let's say I'm mad at my kids for doing something, or let's say Trayvon Martin, you know, he's walking down the street, he has a hoodie on, he got Skittles, and he's doing something. He's on his phone, yakking, talking. Is that suspicious behavior? Yeah, maybe, but how do I conduct myself in the street? Do I
how
have
do you determine what's suspicious and what's not?
Right.
There's no rules on what's suspicious. And that's why
Right.
you have people that are pulled over by on a traffic stop. You
Right.
know, they say if you have a reasonable suspicion, then you can search. But what's the reasonable? Who determines what reasonable is? That's the biggest question.
Oh, wait, I just noticed in my notes, I misspoke. The Terry v. Ohio was the suspicious behavior case. The map case is if you're searching for one thing and you find something else.
Okay.
So if I say, because a warrant, guys, when they have a warrant to come into your house, it has to be specific. This is what we're looking for. You can't have a warrant and just come in and tear my house up. You're looking for whatever it is you're looking for. That warrant has to be very specific. But if I'm looking for drugs and I find pornography or whatever, I find something else illegal, that was not admissible because that's not what you were looking for. So in other words, these Fourth Amendment cases that I saw were reducing police power, which I thought was very, very important. Which led to a lot of, like you said, if you are suspiciously walking down the street, or if they're coming in to look for this and they find that, when you look at these court cases, if it happens to you, you need to look up Fourth Amendment.
Yeah.
Just look at Fourth Amendment, like when you questioning, because by the way, the amendments override any law.
Yep.
How about that? So if they throw a law in your face, we have a right to do this and we have a right to do that based on our state law. You, as a citizen of the country, have a right under the amendments to the Constitution. That overrides everything. So let's move, Tiff. I thought Fifth Amendment was interesting only in the case of the slave that sued for his freedom. Now, at that point, we were property. So Dred Scott, was in the 1940s, and he was a slave, and his slave owner moved him to a free state. Is he free?
No, he's still property. So supposedly. Property.
He's still property. So
stolen property or moved property.
Yeah, he's moved property, but his owner died. So when his owner died, he felt he was free.
Yeah, but then it goes to the heirs of just like regular property. When you talk about slavery, property when David and I pass on, the property will go to our kids. So if our paperwork is correct, but I mean, hey, that's unfortunately that was the law.
That's exactly what happened. That's exactly, guys. It's very, when you read it, it's very interesting. The way they pick to argue certain things. It's very interesting that they really ruled that under the Fifth Amendment, because we always think Fifth Amendment is, I plead the Fifth, I have a right to not incriminate myself, but it also goes to life, liberty, and property.
Yeah.
So they ruled that he's property. You can't free yourself of it. So I just thought that was just an interesting case. And it's interesting in terms of American history, because eventually we're going to have to deal with that, some of the things that are on the books. There's also another case on the books. I didn't put it down in my notes, but it was a case on the books, and it's still on the books, where women were forced to get to be sterilized.
Wow.
So there was a woman that she was considered mentally disabled, although she was raped, molested, and all these things, and she was in foster care, and they forced her because they found her to be an imbecile. They called her an imbecile, forced her to become sterilized, and that case has not been overturned.
Wow.
I know you probably can't. I don't think you could do, but you know, there are recent cases of women on the border. The women on the border that have been forced to get hysterectomy.
Yeah, I have to look at that case that you're talking about. I have to look. I'm not even familiar with that one, but
I can give you the name. Give me a second. Let me look at the name of the case. But it was
I don't have my pen, but I do want to look that up.
Yeah.
But yeah.
Oh yes, Buck. It's called Buck v. Bell, 1927.
Okay.
So if you're watching this, you could just see it's a Buck v. Bell. She was ruled to be an imbecile, and they sterilized her.
Wow.
Forced to be sterilized. And that case is not, according to my notes, they said it still exists on the books. So by the way, if you say, how can a case still exist on the books? If you don't sue the court system, case is still there. Because the judges, right. The Supreme Court does not go out and find cases. They only overrule cases that come to them. So you have to sue in order for this to be an issue. So I don't think anybody's forcing you to get sterilized now. That's probably why it's still on the books, because nobody's questioning it, because it's not happening anymore.
It hasn't been a problem. Right. And I know the Supreme Court handles the most controversial cases and the ones that are where the laws in the Constitution are a little vague or they need clarification. So
or they conflict with each other. Yeah.
Yes, and we know the Supreme Court is the highest court in the land, and the Constitution is the highest, the supreme law of the land. So that's why there's so many amendments, because even though that when was it written, in like the 1700s? There's been many changes that needed to happen to that, and there's a lot of interpretations happen. So,
and in order for these cases to be, in order for you to file an amendment, you got to get like 30 something states to agree.
Yeah,
that's usually not going to happen because we're so divided as a country. Like the whole Midwest, from up top all the way down to like South Carolina, you know, that whole middle where you saw the Electoral College map is so heavily Republican. And then the outskirts, California, New York, you know, the borders are so heavily Democratic that to amend the Constitution, you got to get them to kind of agree. And I mean, depending on what you want amended, that's why the Electoral College probably will never go away. Because I don't see small states agreeing to get rid of the Electoral College. I don't see it.
Yeah, and I mean, there's other ways around it or other ways to achieve it. But I mean, look, it's one of those things where I can't even find the words for it, but it's one of those things where I lost my train of thought. Sorry.
Well, you talking about getting around the Electoral College.
No, I was thinking about something completely different. I was thinking about just how, like the conflicts within the Constitution, and that's why there's so many different amendments. Because, and if you think about now, there are no this freedom of speech and how it affects even online activity. That's something that's going to be brought before the court. I'm pretty sure, because it's on its way. So it's the current issue. So it's just so. It's so much. That's all.
So lastly, I wanted to talk a little bit about the 14th Amendment, because it looks like that's where a lot of our cases were held. So 14th Amendment is like equal protection. That's one of the civil, they call it the Civil War Amendments, 13, 14, 15, where it's ending slavery, giving citizens rights. And then, so the 14th Amendment, I want to be sure I say it right, is citizenship rights. So that falls, the census falls under that. Voting falls under that. Being 21 years of age to vote and all of that kind of stuff. Running for office and to run for office, you must agree to take an oath. It gives Congress the right to enact laws. So that's all 14th Amendment. That's why you see a lot of the cases, LGBTQ plus rights and all that. It falls under 14th Amendment rights, equal protection.
Equal protection,
yeah. So we have a lot of cases
under the law.
Equal justice under the law. So when you feel your rights, that's why a lot of the cases like Ahmaud Arbery, Breonna Taylor, George Floyd, those cases, if you wanted to go to the Supreme Court, you probably can find what rights were violated. 14th Amendment, search and seizure rights, those 4th Amendment, 14th Amendment, probably. So Plessy was one where the law, that was one of the cases that historically America should be humiliated to have agreed to. Plessy sued, but the bottom line of it was, it said that the law is colorblind. That's the bottom line of that law, and we know that that's absolutely today not true. Which led to Brown v. Board of Ed, and I know you had that one. So I know you wanted to say something about Brown v. Board of Ed.
Well, I mean, I know one of the questions that we talked about in the beginning was, why does it matter? Why do these cases matter? It matters because it's part of how your life is affected today. So I have Brown v. Board, I have the Loving case. So right now we go to school with our most of our neighborhoods are diverse. Most of them have white, Black, Spanish, Asian. So that diversity wasn't always, it didn't always happen in America. So when you look at Brown versus Board of Education, we're all aware of that case, but they had the doctrine of separate but equal. But how can you have equal when it's separate? So if it's all equal, why would you have it separated? And that was basically the basis of Brown versus Board of Education. One of the curious facts, and this is how when you elect a president, you elect the Supreme Court, because while the case was about to be presented, one of the justices passed along, and the president at the time had replaced him with a person, what's his name? Oh my goodness, I had it written down somewhere. Earl Warren from California.
Yeah, Justice Warren.
Yeah. So he was really, he was instrumental in getting a unanimous vote or a unanimous decision on the Brown versus Education case, because he's like, basically what they decided, like I said, is how can separate be equal? And if it's equal, then we should all be able to go wherever we want to go as far as school. Now, what they did, which was a problem, which caused a lot of issues in the South, they left it up to the states to implement that. So of course, when you have a new rule, how do you implement that? How do you, just like with the mask mandate today, how would you implement that if it did come from the federal government? You would have to have each state have a regulation, and that's where the Topeka case, where they were integrating the Little Rock, what is it? The Little Rock Nine, I think.
Little Rock Nine, yeah, the Little Rock Nine.
And then you have Ruby Bridges, where the entire school decided to leave versus going to school with a Black girl, a 6-year-old Black girl. The parents pulled their kids out of school so that they wouldn't have an integrated school. That's how much it was fought against. So when we look at now, we're all in the same school together. We're all, going, in some ways it's still a little separated, because you notice there's a certain thing called white flight, where certain neighborhoods, they go from being one persuasion and they slowly change to another. So there's some schools that are predominantly white. There's 95% are white, 95% are Black. So 95% are of Latino. The students make up 95% of the school population. So when you have certain things like that, it's still separated, but it's not meant to be that way. We're all supposed to be able to go, because it's not separate. It's supposed to be, we're integrated. It's supposed to be.
Right. Believe it or not, guys, those cases, that's still going on right now. Even in Brooklyn, there was recent cases of an affluent area in Brooklyn that they wanted to try to keep it that way. Yeah. So the city had gotten rid of zoning. So in other words, you can't just make a kid go to a school in his neighborhood. He can go wherever he wants. While that is the case, it's still a lot going on. Even if you look at schools on like Long Island, where the schools are more affluent, even the public school feels like a private school. But in Brooklyn, where you don't pay as much taxes, that's how they get you. You don't pay as much taxes into the school system. So the school is not as equipped. And then they got these funds the government give you, but when the government gives you funds, they're going to overly mandate you to do this, 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 and this. So I used to teach in Title I schools where they give you money, but like the kids get free lunch and all that. But the supplies are much better than in a school. I went to two separate city schools, and I can tell you right now for sure, I taught in 2 separate city schools. One was a Title I school where they got funding. Teachers were able to make copies and do whatever they needed. The other school was a little more affluent because, you know, they based it on the income of the neighborhood. And in this neighborhood, the kids were a little more affluent, and teachers had to do everything themselves, pay for everything, make all their copies and all that stuff themselves, buy their own paper. And it was disgusting. So, and it's still the city. It's still New York City school.
Yeah. Yeah.
And so that's still an issue. It's not equal.
But that's
I
where
absolutely swear the schools is not equal. I've taught in 4 different schools. It's not equal. It's not equal at all.
So, and that leaves the problem of when you leave certain regulations to the state or certain laws to enforce by the state, they make their own rules. And that's true with voting rules. That's true with so many other things. I did want to go into the marriage cases. So we have, like I said, equal protection, equal justice under the law. So we have the gay marriage, and the one case that affects, now you see so many mixed race couples. You see so many kids. Barack Obama was one. Kamala is one. You see that's, we don't even blink an eye anymore when we see.
Can I just say something about that 1 second? That's interesting that you say that, because if you saw a lot of the president's rallies, what was he saying? They're going to come to your suburban neighborhoods. They're going to, you know, suburban wives, you know, minorities are going to come in and make crime. And I'm like, where do you live? That's not the 50s. It's not. The Loving case was what, in the 60s?
It was,
67. So in the 60s, maybe you can make that speech. But I'm like, where is he from?
I don't know.
Suburbs are so mixed now. But anyway, I'm sorry. I just wanted to. That made me think of.
Yeah, they are, and so when like I said, I have a lot of mixed race friends. I have a lot of interracial couples. So when you couple friends, and when you think about the Loving case, it was a Black woman, a mixed race woman, a Black and Native American, and a white man. They fell in love and they got married in DC where it was legal, and then they moved back to Virginia where their home was, and they were convicted of what is it anti-misogyny or misogyny, one of the two. They were convicted. Basically, interracial marriage was illegal, and so they fought. Loving, the wife, she actually wrote to Robert Kennedy, who was the attorney general.
Right.
He took on the case, and they looked at it, and they said, they actually were extradited. They were kicked out of Virginia because of loving each other.
You're evicted,
they spent a lot of time out. But the gist of the case, I'm trying to look at my notes. I have it on a computer. They actually compared it to incest and polygamy. Just the fact that you would love someone outside of your race was compared to that. And unanimously on June 12th, let me just let you know, June 12th, every June 12th is Loving Day. It's appropriately named Loving. But they made the unanimous decision that it did not provide equal protection. That law was against the Equal Protection Clause, which is the 14th Amendment. And that goes with the same with the gay rights marriage. It's the same thing. It began in the 1970s with the Stonewall riots and people filing for marriage licenses, same-sex marriage licenses. And with that, I'll tell you, you know, people always say that Democrats are for they're more liberal than they are, but Bill Clinton actually signed the Defense of Marriage Act, which indicated that marriage was only between a man and a woman.
And that haunted him for years. That haunted him.
Yeah, but and I mean, you make the decision that you think is right at the time that you're making the decision. But in 2000, they started doing civil unions and saying, okay, the civil union is fine, but that never was recognized on the federal level. So when they actually decided that gay marriage was protected under the equal protection and equal access, they were given rights to probate, rights to file taxes, to rights to, it was more than the salacious thing of, okay, 2 men are marrying each other or 2 women are marrying each other. It's the laws, the federal access that you have to being their spouse or being listed on their death certificate. So that's what they were.
That I found that interesting. The case I saw that was more recent was in the 2000s, where they had the guy, they wanted to, I think he wanted to be on the death certificate or something. Those are just things that, I mean, we always talk about things like white privilege, but there's a such thing as just privilege in general when you don't haven't experienced. So if you're not experiencing homosexuality or trying to get your rights, gay rights and stuff, you don't even think to yourself, death certificate. That doesn't occur to me as just walking around like, oh, I may need to, if I had a female partner and we wanted to put our names on the death certificate. We don't think about that kind of stuff. So when I saw that case, I was like, I never even really thought about that. But when you have to fight for your rights at every single level, even now we take it for granted. From the Loving case, which was a movie, right? With Leela Rashawn, I think had a movie on it. It was a movie. And I think they even maybe, I don't want to misspeak, but I thought it was a remake. They did another one. But I know Leela Rashawn played in one where it was called The Loving Case. Just things that you don't think about in terms of your person. You have rights, so you don't think about other people not having those rights. But the LGBTQ rights are still going on now with health coverage. Just right now, they were talking about transgender. Now there's oh Lord, transgender. I'm not starting. Transgender rights right now are really in focus now, becoming more and more in focus. I know, like in certain states, paying for you to change your gender, and health coverage denying you those rights to go through the medications that you need and the surgery. Man, I'm telling you. Oh, just a few honorable mentions I thought of. Very controversial. And when you think about current, what I thought about for current stuff, we definitely got to talk about Miranda. Okay. So, your right to be most people know you have a right to remain silent and this and that. But before that, Gideon Wainwright. Gideon versus Wainwright was a case, the original case in 1963. When he was, I guess, convicted and he didn't have a right to an attorney, or he couldn't afford an attorney or whatever. And so that became a law of you have a right to an attorney. And then it was upheld again in Miranda. So Miranda actually was convicted of rape and kidnapping and rape, and he confessed. But then he argued he didn't have a lawyer. So they upheld it that, hey, he had a right to an attorney. So you have a right to an attorney. That is under the 14th Amendment. If you don't get, there was forced confessions, I think, even in the Central Park 5. Yep. They forced them, and they were young. Now, that was a newer case, and it was more based on their age. You got a right to have your parent if you are a minor. You can't question my child.
But then, unfortunately, in that case, a lot of the parents weren't educated enough to know that, they themselves had the rights to say, okay, well, we're going to stop this interview, or we're going to wait until we receive a lawyer. And so that's where, and you see a lot of cases where they discuss their Miranda rights, where their Miranda rights violated. And they were when you don't have a parent, or you don't have a parent that, ignorance of the law is not an excuse, but when you have a parent that doesn't speak English and doesn't understand what's going on, then how is it that you were advising them? Like how were their Miranda rights protected? So that's something that's really a big deal.
That's why knowing the previous cases matter, because I believe in the Wainwright case, that was one of the issues of having a competent lawyer. Yeah. Was the issue. Do you have a competent lawyer? They're giving you a court-appointed person that just got in the system, don't know the laws, and he's, how they'll just, if you're poor and you don't have a right to an attorney, they give you somebody as maybe even almost a student. Yeah. So that
what case is this? Like, what's your case?
Wait, I have whatever your name is. That is against your 14th Amendment rights. You have a right to a competent attorney. So other cases that I thought were interesting, there was a right to die in 1990. You have a right to take your own life if you don't want to live. Not like I just want to commit suicide. Not you just want to commit suicide, but I mean if you're sick, because it was a case of a person that was a beautiful young girl that was in a car accident, and she was incapacitated and was never. They said she could live 20 years on a life support, and her parents wanted to take her off life support. So they fought to have her be able to take herself off life support. So quality of life. So they and that was under their apportionment 1964. We have a right as citizens in our state. If we find that this is like we're not properly represented, we have a right to be reapportioned. And that's what the census does too, reapportion according to your representation so that you could get funding and you could be properly counted. That's 14th Amendment. So guys, what I did, Tiff, I put a link, or I put up our playlist, and I do have a thing in there. It's called the 10 most landmark cases. Of course, Gore is in there. Gore is now in question because we now have this election still going on in some aspects because our president has not conceded. So he has not said, okay, I agree, I lost. Gore case keeps getting referenced. And so Gore was where the Supreme Court stepped in and said, stop the counting. And this was like, right now, Biden is said to have 306 votes to the president's 232 or whatever. It was not a Gore type situation. Like, Gore was literally 269 to, they literally were that close, neck and neck.
Yeah, they were. It was whoever received Florida would receive the president.
Would win.
But the difference with that case versus now, first of all, the cases or the evidence that's being provided isn't even making it past the lower court. So to make it to the Supreme Court is going to be a big feat. But then they also said to stop the counting that was being recounted. So it wasn't like, okay, stop counting new votes. It was stop counting the recount. So that's a big difference. The counting that's going on or that just stopped recently, to stop that's actual votes of people. So you can't
that's a violation of your rights, your 14th Amendment rights of that state. So Pennsylvania, Wisconsin, Michigan, Arizona, those states are actually, your rights are being violated if they stop the count. Yeah. So you guys,
why do you think he didn't want to stop the count in North Carolina or Alaska?
He was already winning there.
Okay, just wanted to know.
It's interesting to stop the count. Okay, stop the count. It's so ridiculous because, first of all, he said I went to bed at 12 o'clock at night and I was winning, and then I woke up in the morning and they have found all these votes.
Yeah,
that's number one. They were still count. I found out they still count. Yeah. Even that, the states have the power to say when to stop and when to keep going. And it was already known that was going to happen because mail-in ballots were legal up until 2 or 3 days after the election because it's mail-in ballots, which, by the way, you attacked the post service. So the votes were not going to get there in time.
I hate to beat a dead horse, but I would say since like April, the writing was on the wall. If I keep saying, hey, Cindy, this is going to happen when November comes, and this is going to happen when November comes, with this, like, no evidence of why I keep saying that. But then when November comes, it happens, so to speak. And I say, see, I told you it was going to happen. That's pretty much what he knew. And as
he's a prophet. He's a prophet.
He knows the law and how they're supposed to be counting. He knew that was going to happen.
He knew. And so that's why he called it. That's why he said stop the count.
Skepticism. But if you stop the count when he wanted to stop the count, he was losing in a few states, so he still would have lost. So
I agree with him. Stop it.
Yeah, right now. And for those people that don't follow elections as close as they have this year, those counts usually take place. If you look back at any, and to be fair, Gore did not concede until December. So let's give this president, he's not used to, or he doesn't like losing like most of us. Let's give him some time, as long as he doesn't blow up the entire, system. He needs the time. It's the denial, the acceptance, the anger, or whatever the
stages of grief. The stages of grief.
Let him play that out while he's on the golf course.
The only thing though, Tim, the only thing is that he's also doing things with the military, and he's also dismantling parts of government. He's also keeping Biden from having access to certain things. Yeah. Now he's also keeping the money. Now the GSA is basically the landlord of the government, as you know. So if the GSA is the landlord of the government, they have the keys to everything, and they're not giving Biden the keys to certain things and let him have access. They're also supposed to give him like millions of dollars to start his, hiring people. So,
and you know what? Guess what? Everyone sees what's going on, and they're still plugging away. They're still selecting people. And if I was to be selected to his cabinet, I would work for free until we got those keys.
Absolutely.
And whatever we needed.
Well,
but I think what we're gonna do is we're gonna start a second video to discuss the current what do you call it? The current cases like DACA, the ACA, and the voting rights. What do you think? Do you think we can
we could do that. We could do that. We could just stop it here. And then talk about the current stuff, because I think the current stuff we need to know about, because we need to be involved in action groups that can file briefs to influence those cases. I think that's very important.
Definitely. All right. So we'll have a second bonus video. If you do not watch that second video for the current Supreme Court cases that are going on, you can always you should watch it. Just go and watch it.
Watch it. Stop it.
But we want to always let you know about our email to polychicks@gmail.com. Follow us on Facebook. What else is it? I always forget. Facebook,
Twitter, Instagram.
You'll find us, Polychicks.
Yeah, Fig. What is it? Fig. Facebook, Instagram. Fit. Facebook, Instagram, and Twitter.
Fit. Okay. And wait, and YouTube. Sorry.
Fitty.
It's early in the morning when we take. All right, guys. Have a good one. We'll see you on the next video.
Bye, guys.